Good afternoon. My name is Marion Orr. I'm the Fred Lippitt Professor of Public Policy and Director of the Taubman Center for Public Policy. I want to welcome all of you here to this event. This event is co-sponsored by the Brown Daily Herald, an independent student-run newspaper, and the Taubman Center. And let me just say that the idea of putting on this forum focused on same-sex marriage here in Rhode Island originated from the student reporters who cover the state and local issues here for the student newspaper. And I work closely with Sona and Adam, two reporters for the BDH, to put together this forum. This is the first time that the Taubman Center has partnered with the student newspaper to put on such a forum, and we're anxious to see what happens, to see if we would do this again in the future. Same-sex marriage is being discussed right now in the Rhode Island Senate Judiciary Committee. And the issue, as all of you know, is whether or not gay and lesbian couples should be allowed to enter into marriage. Now, we're not only discussing this here in Rhode Island, this is a national debate that's been going on now for a number of years. And when you look at least national polling data, you can easily discern a shift in public's views about same-sex marriage. In fact, the polling results in many instances are quite clear. For example, a Pew Research Center poll conducted in 2003 found that most Americans, at that point 58%, oppose allowing gays and lesbians to marry legally, and just a third in 2003 were in favor of this. Now, a more recent survey by Pew conducted in March of this year confirmed the shifting public support. And the recent Pew poll showed that some 49% of respondents now support same-sex marriage, and the Pew poll found that some 44% oppose it nationwide. Now, the Taubman Center back in February conducted its own poll. We did a poll of some 600 registered voters here in Rhode Island back in February. And we asked a simple question of registered voters: do you favor or oppose allowing gay and lesbian couples to enter into same-sex marriages? And the poll found that 60% of the registered voters in this state, in our state, said they were in favor of allowing gay and lesbian couples to marry, and the poll showed that only 26% opposed allowing gays and lesbians to enter into marriage. And then finally, about our poll, we found that this issue, that people hold this issue very, very close. So for example, when we asked folk in this poll, do you strongly favor allowing same-sex marriage? And some 62% said they strongly in favor of this notion, which sort of gives you some sense of the intensity around this issue. A similar number, about 60%, said they strongly oppose allowing gays and lesbians to marry. And then finally, in our poll, we wanted to look at what's driving the supporters. and what's driving the opponents. Among those who favor, we found that one of the largest drivers is this whole question of equality. Those who favor it say it's just a matter of treating people fairly. Okay? And that's why they favor and support it. Among those who oppose it, we ask, why do you oppose? And a large number of those folk in our poll said they oppose it along religious and moral grounds. Said that the Bible said that men and women should only marry. So you have these very strong values that are driving the opposition, and that's driving those who support same-sex marriage. So it's a fascinating and very important issue. Now, I'm going to ask Adam to come up. Adam helps cover state and local issues for the Brown Daily Herald, and I want Adam just to update us, because as we speak, the things are happening on Smith Hill around this issue, and Adam's going to come and give us a brief update on what's happening right now, and then we're going to turn over to our panelists. Adam Taubman, please come.
So first, on behalf of the Herald and my co-editor, Sona, I'd like to thank everyone for coming. Thank you to our panelists, and in particular thank you to Professor Orr, Ellen, and Isabel at the Taubman Center, who were very enthusiastic and helpful from the beginning and helped us get this together. So the news bulletin. About an hour ago, the Senate Committee on the Judiciary passed Senator Donna Nesselbusch's proposed legislation that would legalize same-sex marriage in Rhode Island by a vote of 7-4. The committee also voted to defeat proposed legislation that would put the question of same-sex marriage up to a statewide referendum by a vote of 5-6. They scheduled the vote for the full Senate because as a result of the judiciary vote, the full Senate will vote on same-sex marriage for the first time. It's scheduled for 4 p.m. tomorrow. It's the exact legislation that passed the House in January by a vote of 51-19. If it passes unamended, it will go to the governor, and he has indicated that he will sign it. If it is amended, which is a possibility, it will have to go back to the House, but we will see tomorrow. Thank you.
Thank you, Adam, for that news update and news bulletin. Now we're going to turn over to our panelists. I believe all of you should have a list with the bios of our speakers. I don't want to take too much of their time reading their extensive bios, but let me just call them out, and then they're going to proceed in terms of how they're listed there in front of you. Starting first will be my distinguished colleague here at Brown, Professor Robert Seth. Followed by Robert will be Courtney Cahill, who is a professor of law at Florida State. Christopher Plant was expected to be here as part of this panel. Mr. Plant, however, is very ill, and at the last moment he was able to help recruit Miss Celia Wolf Devine, who is going to speak in his place. She is a co-author of an anthology on sex and gender. Followed by Ms. Devine will be Jansen Wu, who is a staff attorney with the Gay and Lesbian Advocates and Defenders. Followed by Mr. Wu would be the Reverend Thomas Petrie. Did I get that correct? Father Petrie is here because the Bishop Taubman of the Archdiocese could not be here, and so he recruited Father to be a part of this panel. And finally, our last panelist would be Rabbi Sarah Mack, who is the associate rabbi at Temple Beth El. She's been there since 2003. So we're going to let the panelists proceed, and we've given them a task of covering this very, very important topic in 10 minutes each. Okay? And Adam, and they're going to help me try to keep the time, because what we want to make certain is that we leave time for some exchange and dialogue and ideas, okay? So we're going to monitor you very closely and try to keep you on the time limit, not because we don't want to hear you, but we want to hear what you have to say, and we want to make certain we engage this large audience. So let me start with Professor Robert Seth.
Thank you, Professor Orr, and thank you all for coming. I'm delighted to be here. My role on the panel today is to provide a kind of historical perspective on the contemporary debate about marriage equality. And of course, there are a number of ways that we could do that. There are a number of contexts of historical frames in which we might situate it. Since Professor Cahill, to my left, is going to discuss the legal context, I'll limit my comments to a discussion of two historical dimensions that I think are particularly critical. The first is marriage as an institution regulated by the state, by government, and marriage as an objective or goal within what we might loosely call the gay rights movement, or the long gay rights movement, which of course includes a great deal of variation. So first, I think it's important to understand that in the United States, marriage has both a religious and a secular history. Religious pluralism in the US has meant that the religious history of marriage is itself plural, although its characteristics vary, I would argue, within a relatively narrow range. Various Protestant denominations, the Catholic Church, Judaism, Islam, have, over the last couple of hundred years, expressed distinct views of divorce, for instance, or expectations about child rearing. Prescriptions against infidelity have varied over time, and so forth, all within a religious context. Most religious traditions, of course, understand marriage as playing a critical role in a divinely ordained earthly plan for human beings. Marriage is part of God's, however that God is defined and understood, part of God's plan. Marriage is even in some traditions understood as critical to the relationship between individuals and the divine. Whatever the distinct religious histories of marriage, in the era of the modern nation state, it has been a critical secular institution and has a critical secular history. For our purposes in the United States, marriage has since the founding been an institution defined by state law. This is part of the complex division of powers in the United States with which you're familiar, in which virtually all matters of civil law are regulated at the state level. More pointedly, marriage in the United States grew out of the 18th century English common law system known as coverture. Marriage was understood as a contract, and it was regulated as such. In the first decades of the existence of the United States, most state marriage laws, for instance, gave the husband legal control over his wife's labor, as well as the labor of their children. These were contractual obligations. States issued marriage licenses, defined the contractual terms of marriage, regulated who could and could not marry, that is to say, regulated who had access to the institution itself, and prescribed how and under what circumstances marriages could be dissolved. Over many, many decades, marriage as a contract between two individuals changed a great deal, as you might imagine. For one thing, its terms became gradually more mutual, and here I'm speaking in relative terms, gradually more mutual, less organized centrally around the rights of husbands, although of course there are still important dimensions of that remain. Amidst the momentous changes in how marriage has been structured and regulated, one aspect has remained constant. Marriage stands as one of the principal legal institutions through which states regulate an enormous range of social and economic relationships. It affects property and property acquisition and distribution. It affects taxes and other financial obligations. Marriage structures a whole set of legal obligations toward children. And marriage law is embedded in countless ways in both state and federal welfare and social security laws, laws related to credit and other financial matters, laws related to health insurance and health care, and the rights and obligations of couples in all sorts of institutions, including schools, hospitals, prisons, and so forth. The legal history of marriage as an institution of the state is a long one with a great many turning points, and I obviously in my time can't summarize them all. And I know that within the politics, the larger politics of lesbian, gay, transgender, bisexual rights, there are many, many different perspectives and many different points of view about marriage itself as an institution. I want to recognize that because I know there are very different points of view in the audience about whether, in fact, marriage ought to be the central goal of a gay or lesbian politics, and the role of marriage itself within the larger political and social structures of the United States. I recognize that there's a great diversity of opinion about that, and what I'm endeavoring here to do is to kind of give the historical context and framing. So now let me turn briefly to marriage as it's been understood within longer-term lesbian and gay politics. The power of marriage to confer both legal and social respectability means that marriage has enjoyed a complicated history within what we might call the long gay rights movement, a roughly 60-year history that dates to the early 1950s. That history, like the history of marriage itself, contains many twists and turns. Phases, changes in naming and definition, from the homophile movement of the 1950s and 1960s to our contemporary language of LGBTQ. In one of my courses, and in that course I see lots of student faces in the audience, I spend roughly 2 hours explaining this trajectory, so you'll forgive me for condensing it very, very quickly. In the constellation of legal and cultural arguments made by generations of lesbian and gay activists, marriage was not always front and center. Indeed, prior to the mid-1970s, other issues and claims predominated. Demands for sexual privacy, repeal of sodomy laws, passing protections against discrimination in housing and employment, and so on. In short, efforts on one hand to make the law neutral regarding sexuality, and on the other to enact protection against discrimination based on sexuality. And of course, activists themselves were divided over whether marriage rights were a proper or worthy pursuit. Nevertheless, demands for marriage rights were always present within lesbian and gay movement circles. Setting aside for a moment the informal marriages and marriage ceremonies that had long existed in lesbian and gay circles. Formal discussion of marriage and marriage rights were part of the discussion as early as the mid-1950s. Some of the first legal challenges against same-sex marriage prohibition took place in the early 1970s. One of the ironies of the lesbian and gay rights movement is that these initial efforts in the early 1970s to legally wed led many states for the first time to explicitly define marriage in heterosexual terms. It was actually not defined as such in the law. Two broad developments within lesbian and gay communities altered the priority given to demands for marriage rights. The first came from lesbian activists themselves, who rewrote family law in many states, or who pushed the rewriting of family law in many states. Many lesbians, and I have about 2 minutes, many lesbians in the early 1970s were in straight marriages. When they came out of those marriages, left those marriages, and as the phrase went in the 70s, came out of the closet, many found that local family court judges would not award them custody of children, or sometimes even award them visitation rights. Or if judges would award them custody or visitation rights as single people, as soon as they formed new same-sex partnerships, their parental rights were again threatened. Moreover, beginning in the late 1970s, there was what one historian has called a lesbian baby boom. Both processes brought home to same-sex female couples that the lack of cultural and legal codification of their relationships placed their children and their relationships with their children in constant jeopardy, and I'm winding up here. The second development that brought marriage greater attention and greater focus in gay rights circles was the HIV/AIDS epidemic in the 1980s. From the beginning of the early 80s through the extraordinary wave of illness and mortality in the late 80s and early 1990s, and indeed down to our own day, the epidemic brought home to people how central marriage is in the United States in shaping how healthcare and health rights are imagined and distributed. I want to close by stressing two things. First, there is a difference between a historical account of marriage in lesbian and gay politics and the legal and philosophical arguments on behalf of marriage equality. They are not the same. I am not saying, for instance, that because of HIV/AIDS, there should be marriage equality. Nor are the current advocates of marriage equality saying that. There are legal, cultural, philosophical, and human rights arguments for marriage equality. The foregoing was really a historical recounting of how it came to be more important in those circles. Second and finally, marriage is the most powerful institution in American life for conferring cultural and legal respectability. Its long history of conveying that respectability to some and not to others, and its long history of regulating property, labor, privacy, and myriad other rights suggests that it will remain central to how Americans define and understand the content of citizenship. Thank you.
Thank you. So I'd like to thank the Taubman Center for having me here to give a legal perspective on the national marriage equality movement. My remarks this afternoon center on 3 issues pertaining to marriage equality. The first issue relates to the so-called novelty of same-sex marriages and of the marriage equality movement more generally. The second issue relates to the legal arguments that litigants are making in marriage equality litigation and to the potential consequences of those arguments. And the third issue relates to a question that Justice Scalia posed to Ted Olson, who was arguing on behalf of the same-sex couples in the Proposition 8 case, during the Supreme Court oral argument in that case a few weeks back, I guess almost now a month ago. So starting with the first issue, the so-called novelty of marriage equality. If you listened to oral arguments in the Prop 8 case, you probably heard the line of questioning by a few justices pertaining to the alleged newness or novelty of the same-sex marriage issue. Justice Alito made a reference to same-sex marriage being newer than cell phones, and Justice Kennedy cautioned against moving too fast because this is a new issue. I have 3 comments here with respect to the novelty issue that has been circulating around marriage equality. First, same-sex marriage isn't new as an institution. Legal historians have long shown that same-sex marriages have existed in myriad cultures for centuries. Formal, ritualized same-sex unions existed in ancient Rome and China. Informal same-sex unions, of course, existed as well. We just didn't call them quote-unquote gay marriage because the concept of homosexuality and of sexual orientation more generally weren't invented until the late 19th century. Second, and more specifically, marriage equality itself isn't a new issue, as Professor Self has pointed out. The first marriage equality case was litigated in Minnesota in 1970 and went before the Supreme Court of the United States in 1971, the year I was born, so I know it was more than 40 years ago. That is more than 4 decades of marriage equality litigation. Most of this litigation has taken place in state courts under state constitutions rather than under the federal constitution. California's Proposition 8 case, Hollingsworth v. Perry, is the first time in a very long time that someone argued that a state marriage law that prohibited gay people from marrying the person of their choice violated the federal constitution. But litigants have nevertheless been pressing similar claims in state courts under state constitutions, for years. Third, even if marriage between same-sex partners were completely new, even if, say, the concept of same-sex marriage started yesterday, why does novelty matter when we're talking about constitutional rights? It can't be because the framers of the Constitution weren't thinking about same-sex marriage when they wrote the Constitution in 1787 or the Bill of Rights in 1791 or the 14th Amendment in 1868, because constitutional protection extends even to things that weren't around way back then. The First Amendment, for instance, protects all sorts of communications, including the internet, that weren't around when the First Amendment was passed in 1791. So the ostensible novelty of same-sex marriage is a curious thing to be obsessing over, I think, when appraising its constitutional significance. In short, things get constitutional protection notwithstanding their newness. The second issue that I'd like to turn to now is this. What are the legal arguments that are being made in favor of marriage equality, and what are their consequences? So litigants have made all sorts of legal, that is to say, constitutional arguments for why laws that prohibit same-sex partners from marrying each other violate the Constitution. Some litigants have argued that marriage restrictions are an impermissible form of sex discrimination because they classify people on the basis of sex, and this argument really makes intuitive sense in the sense that the only reason why 2 women or 2 men cannot get a marriage license is because of their sex. Others have argued that marriage restrictions violate the First Amendment. Most of the time, though, litigants have made 2 constitutional arguments. First, that marriage restrictions violate the fundamental right to marry that is protected under the federal Constitution. And second, that marriage restrictions violate the Equal Protection Clause of the federal Constitution. The first argument, the right to marry claim, focuses on the right that is being withheld from same-sex couples. The second argument, the equality argument, focuses on the class that right is being withheld from, namely sexual minorities. The merits brief and the Prop A case made both arguments, which really reinforce each other insofar as marriage prohibitions are denying a right, namely the right to marry, from a class of people. In this sense, marriage prohibitions simultaneously violate both constitutional provisions. Now, what are the consequences of these legal arguments? In the interest of time, I won't really go into those consequences at length here. Suffice it to say that the equal protection argument, I think, gives you more bang for your buck than does the fundamental right to marry argument, because the equality argument that's being made in marriage equality litigation is more portable than the marriage as fundamental right claim. That is to say, the equality argument can be used in other contexts outside of marriage, whereas the fundamental right to marry argument is largely confined to marriage. The third issue that I'd like finally to turn to pertains to a question that was posed to Ted Olson by Justice Scalia during oral argument in the Prop A case. And let me here read from the transcript. Justice Scalia, I'm curious, when did it become unconstitutional to exclude homosexual couples from marriage? 1791, 1868, when the 14th Amendment was adopted? Sometime after Baker, where we said it didn't even raise a substantial federal question? When did the law become this? Mr. Olson, may I answer this in the form of a rhetorical question? When did it become unconstitutional to prohibit interracial marriages? When did it become unconstitutional to assign children to separate schools? Justice Scalia, it's an easy question, I think, for that one. At the time the Federal Equal Protection Clause was adopted. That's absolutely true. But don't give me a question to my question. When do you think it became unconstitutional? Has it always been unconstitutional? Mr. Olson, it was unconstitutional when we as a culture determined that sexual orientation is a characteristic of individuals that they cannot control, and that Justice Scalia, I see. When did that happen? When did that happen, Mr. Olson? There's no specific date and time. This is an evolutionary cycle. So this is a fascinating question, one of the more interesting questions, if not, in my view, the most interesting question, which came out of the oral argument. I think there are several ways that we can think about this question. That is, the question as to when something becomes unconstitutional, and specifically when same-sex marriage prohibitions became unconstitutional. First, we might say that marriage laws that prohibit gays from marrying the person of their choice have always been unconstitutional, or that they've been unconstitutional for as long as they have been in existence. When the Equal Protection Clause of the 14th Amendment was passed in 1868, the framers who wrote it and the states that voted for it understood it to prohibit caste and class legislation. It was also popularly understood by members of the public to prohibit caste and class legislation. That is, legislation that creates hierarchies of people and or that separates people into distinct classes based on a particular characteristic. Now, same-sex marriage restrictions clearly create classes of people, perhaps even castes of people, because they create a hierarchy or pecking order of sorts, with married opposite-sex couples at the top and unmarried same-sex couples somewhere beneath them. If marriage weren't perceived to be a superior institution, superior, say, to civil unions or unmarried domestic partnerships, then one wonders why it would even be worth fighting for at all. So if marriage prohibitions create classes and perhaps even castes, and if the Equal Protection Clause was originally intended and understood to prohibit such classes and castes, then marriage prohibitions have been unconstitutional since their inception. Second, we might say that marriage prohibitions became unconstitutional in 1996, the year the Supreme Court decided a landmark gay rights case called Romer v. Evans. In Romer, the court made more than clear that the Federal Equal Protection Clause protected gays, lesbians, and bisexuals from discrimination, just as it protects women and racial minorities from discrimination. This was a hugely important decision. Before Romer, it was unclear whether the federal Constitution would protect gay people at all. After 1996, it was more than clear that it did. Third, we might say that marriage prohibitions became unconstitutional when a majority of Americans said they did. Under this view, a sort of popular constitutionalist view, something only becomes unconstitutional once a majority of Americans says so. I don't necessarily endorse this view, but even assuming that it's a valid one, what is a majority of Americans saying today about marriage equality for gays and lesbians? And I won't recount sort of the statistics that Professor Orr read, but various polls say different things. A recent ABC poll put the number in favor of same-sex marriage at 58%, a CBS News poll at 53%, a CNN poll at 53%.
You gotta wrap it up,
Okay.
Professor King.
Fourth and last, we might say that something only becomes unconstitutional once the Supreme Court says so. If the Supreme Court is the ultimate interpreter of constitutional meaning, then doesn't that mean that something isn't unconstitutional unless and until the court says that it is? And I will close here. Not necessarily. Sometimes the court gets things wrong and admits as much. And I'd like here to close with this. In 2003, the Supreme Court decided another landmark gay rights case, Lawrence v. Texas. There, the court struck down state laws that criminalized consensual sexual conduct between persons of the same sex and overruled a prior case, Bowers v. Hardwick. In overruling Bowers, the Lawrence court stated, Bowers was not correct when it was decided, and it is not correct today. In other words, the court made clear that criminal sexual conduct laws were unconstitutional even before the Supreme Court said so in 2003. They were unconstitutional for a very long time, perhaps even from their inception. So bear in mind that sometimes the court gets civil rights cases wrong. Even if it rules against marriage equality in these recent cases, that doesn't mean that marriage prohibitions aren't unconstitutional today. It simply means that today is not the right day for the court to say so. Thank you.
Let me tell you, the remaining speakers have been involved actively in some respect to the local issue here. And so we're going to ask Ms. Wolf Devine to proceed, and we will move from her to her left afterwards. So, please.
Is this on? Ah, it is. Okay. Same-sex marriage is not a partisan issue. Both Republicans and Democrats have split on this issue. I believe that legalizing same-sex marriage is politically the worst move on the board at this time. Our society is becoming more and more bitterly polarized. Alienation from the government, levels of anger are mounting to dangerous levels. Passionate opposition to same-sex marriage is very widespread at the grassroots level and is grounded in people's sincere moral convictions. Forcing this on people without a vote is going to increase further anger and polarization, and I think this is really tragic because we have terrible environment, we have social problems, division, polarization of rich and poor, degradation of the environment. We don't need to put something through that's going to increase the sense of anger and alienation. Okay, now I'm going to argue in this section right here that first, the government has a legitimate interest in encouraging and supporting marriage as traditionally understood, and secondly, it does not have an interest in validating same-sex unions. Heterosexual pair bonding has always been the glue that holds society together and provides a safety net for the vulnerable. It unites two family lineages, providing grandchildren for the parents of both spouses and creating the extended family. It's intended to provide a stable environment for rearing children within those extended families. Same-sex marriage would be, as one lesbian writer in our book, here's our book, puts it, a breathtakingly subversive idea, radically changing the message of the whole institution of marriage. No known society, and here I'm going to differ from my neighbor here, to my knowledge, we could talk about this, but to my knowledge, no known society, even of those that were tolerant toward homosexuality, for example, pederasty in Greece, took them to be marriages. You know, they may have had some status, but I've never heard of that they took them to be knowledge. They would respond with incredulity to this idea. Marriage? Okay. Now, reasons given for changing the institution of marriage I find not persuasive. The right to marry was certainly understood by the framers of our Constitution to be the right to marry a member of the opposite sex. This has been throughout history what marriage was. The thought of same-sex marriage never even occurred to them. Everyone has the right to enter into a heterosexual marriage. That's what we, okay. The analogy with laws forbidding interracial marriage is flawed. The difference between black people and white people is skin deep. Sexual differences between men and women go all the way down. Our organs, hormones, bone structure, brain structure, every cell in our body is sexed. And sex difference is specifically relevant to marriage. Union of male and female is the only way children come into being. Even in cases of, quote, artificial insemination, there's a father out there. Thirdly, I don't think the idea that homosexuals are born that way, therefore it's unfair to deny them social approval that marriage carries with it, does not stand up. There may be some people who've never felt a quiver of bisexuality, but I think this is often ignored in these debates. I think a large number of people are at least mildly bisexual in inclination, and I have personally seen enough people change their sexual orientation that I'm persuaded that sexuality is more malleable than gay and lesbian advocates claim. And on the whole, I think there are good reasons for encouraging wavering young people to go straight. Same-sex marriage would have very bad consequences. I want to focus here on children. People of goodwill should put the needs of vulnerable children first. Marriage is not just about feelings of emotional fulfillment of the adults. I'm very, very distressed that it's become such an ideologically hot issue that careful investigation of its effects on children is simply shouted down. We want to find the truth. How much?
Got about 2 more minutes, Ms. Wolf Divine.
2? Yipes. Okay. This is terrible.
I'll give you 3.
Okay. Okay. The reaction to the Regnerus study. Okay, you've all probably heard about that. I'm deeply, deeply troubled that everyone they vilified him. They personally attacked him. I've read his stuff. He's conscientious. He's careful. He's charitable. And I hate to say it, but this attitude of these signs here is, we don't want to talk. No rational debate. That is really deeply saddening if we're going to live together in a democracy and if we're going to care about the fate of children. Not all homosexuals favor same-sex marriage, as you note. I want to give a few quotes from some handbooks on gay and lesbian parenting that I think are very telling. One says, children of lesbian and gay couples do express a longing for the other biological parent, talking about it frequently and emotionally. It is also true that what is unimportant today may surface tomorrow with urgency. A book on lesbian parenting admits, it is very normal for children to ask about and long for a father. We encourage you to hang in there while your child works through her grief. They encourage father fantasies. Children have a right to know and be cared for by their parents. Many countries in Europe now forbid anonymous sperm donation on that ground, knowing who you are, knowing who your parents are. A French expert in humanitarian law who was raised by a lesbian couple told newspapers he had suffered daily from the absence of a father to provide a masculine example and a counterweight to the relationship between his mother and her lover. He experienced his lack of a father as an amputation and violently opposed same-sex marriage as institutionalizing a situation that deeply scarred him. We need to investigate this all the way to the ground. We don't know enough. You don't want to rush into this. And I want to make one concluding remark. I am not this is not a matter of judging individuals. People raising children in non-traditional families are, on the whole, trying to do their best by their children, and often succeed against the odds. But the basic heterosexual family, I think, is best for children, and that's the only ground for the government supporting it. And I don't see any ground for trying to validate and support same-sex unions.
My name is Jansen Wu again. I'm a staff attorney with Gay and Lesbian Advocates and Defenders. And first of all, I want to thank Marion and the Taubman Center and the Brown Daily for organizing this panel. I also want to thank whoever turned on the air conditioning. Thank you so much for that. I got myself on timer on my phone, Marion, so no need to worry. And I also just want to acknowledge the protesters in the back. I think that the point that the students raised is a very interesting point. I would love to be to the point where these debates no longer happened. And I also know just from the work that I do that it is the conversations that happen that have brought us to the point that we are with a tremendous amount of support for marriage equality. So I think certainly there's a place for debate, and there's also a place for protest. I'm just going to cut straight to the issue. In Rhode Island, there is going to be a vote on the Senate floor tomorrow, and a lot of it's going to be centered on religious exemptions, or what religious exemptions are appropriate in the bill. And so I just want to talk about how this conversation about religious exemptions isn't about religion, it's not about marriage, it's actually about discrimination. And we shouldn't allow the marriage legislation to be a backdoor to undermining this state's anti-discrimination protections. And to make that argument, I just want to give a little bit of a historical perspective on this topic. So there have always been religious objections to the extension of civil rights in our country, always. So if you just want to go back to Loving versus Virginia, which is the case in the Supreme Court that said that states could no longer prohibit interracial marriages, if you read the trial court's decision, which went the other way, the judge in the trial court there actually wrote, quote, "Almighty God created the races white, black, yellow, Malay, and red, and he placed them on separate continents. And but for the interference with his arrangement, there would be no cause for such marriages. The fact that he separated the races shows that he did not intend for the races to mix." And this is not just 1967 we're talking about. This is 2000 when in 2000 when Bob Jones University finally ended their prohibition on interracial dating. And even most recently in 2011, a Kentucky Baptist church made a resolution that it does not, quote, condone interracial marriages. So I think it's so sad that so many of us in this debate have forgotten this long history of segregationist theology. But it's not just with regards to interracial couples as well, too. There are religious objections to interfaith marriages. There are religious objections to remarriage after divorce. And then if we go beyond the marriage context to non-marriage, there have always been objections. There have been objections to women working in the workplace, religious objections opposing women in the workplace. There have been religious objections to the application of drug laws. There's a very famous Supreme Court case about an employee that wanted to use peyote for spiritual purposes and was fired for that, and that went all the way up to the Supreme Court. There have been cases of religious objections to animal cruelty laws with regards to ritual sacrifice of animals. There have been, there's a very famous case where the Amish objected to Social Security as well too, because that violated their religious beliefs. So this debate has been happening in our country since the beginning of our country. And it's only now that the opponents of same-sex marriages are trying to insert religious exemptions into our laws. And why is it? Why is it only now? So what have we had up until this time? We've had a system of laws that has worked. We have had the free exercise protections of our state and our federal constitutions. And Rhode Island is one of the few states that actually has a Religious Freedom Restoration Act, which also provides protections for people whose religious beliefs conflict with the laws. And these laws have been working. The courts can address these situations on a case-by-case basis as they come up. It's foolhardy for a legislature to try to write in explicit exemptions for every single situation that might come up. I just only named a few, but there are so many other times examples of religious objections to laws that exist on the book. And given the enormous diversity of religious belief in this country, legislatures simply should not get in the business of writing explicit exemptions. The other side has been focusing a lot about how there is this need for exemptions, not just for churches and religious organizations, but for individuals, florists, bakers, caterers who are in the wedding industry business, who object to a same-sex couple marrying and don't want to provide those services, even though they are required to currently under Rhode Island non-discrimination laws. I just want to talk about why, and thankfully, that actually was defeated in the Chacon bill, which is the referendum bill, and so hopefully that will not come up again on the floor tomorrow. But I just want to talk about why these individual exemptions, from a very legalistic point of view, are such a bad idea. So, and I'm going to do something I don't usually do. I'm going to quote Scalia. So in that famous case I was telling you about, the Smith case regarding the peyote, Scalia actually ruled against the person who wanted to use peyote for spiritual practices and was fired. And he made an argument as to why these individual exemptions are so destructive to the rule of law in our country. What he said was, quote, to make an individual's obligation to obey such a law contingent upon the law's coincidence with his religious beliefs, permitting him by virtue of his beliefs to, quote, become a law unto himself, contradicts both constitutional tradition and common sense. Basically, it would create legal anarchy if any person can choose which laws they want to obey and which laws they want to obey based upon their religious or individual's consciousness. And that would severely undermine our ability to enforce our laws, and importantly, in the situation at hand today, our anti-discrimination laws. Would that mean then a Jewish baker can refuse to bake a cake for an interfaith wedding? Does that mean a Protestant baker can refuse, a Protestant florist could refuse to provide flowers for a Catholic wedding? Creating individual exemptions and allowing individuals to make those determinations on a case-by-case basis will only foster religious strife, and it won't advance religious freedom. It basically allows people to discriminate against each other based upon their religious beliefs. So, religious objections to aspects of the law, including anti-discrimination laws, are nothing new. We have a system of constitutional protections and statutory protections that are already in place to address those conflicts. So again, I ask, why are we seeking to upend that system that has worked for so long and decades simply because we're discussing the rights of LGBT citizens today? And I'll just end with one note, which is that we're talking so much about law, talking about so much about history, talking about so much politics. I think it's so important to bring this back to what's really important, which are the families who are being harmed by marriage discrimination today. One of the people who testified 2 years ago was Pat Baker. She was a prison guard who was married to her wife, Deb Tevye, and she was diagnosed with lung cancer and didn't have a long time to live, and unfortunately she passed away 2 years ago. At GLAAD, we had a fight to get Deb, her surviving spouse, on the death certificate so that she could manage the legal affairs after her passing. We had to fight to get her name on the car title so that she could drive the car that they owned together. And we are currently fighting so that she can get her Social Security survivor benefits. That's the issue of federal law, not state law, but it's still harmful and horrible just the same. I was just on the phone with her the other day, and she is struggling to keep the house they've lived in for decades because those protections for widows and widowers against elder homelessness are not in place for same-sex couples. It's just one example. I think it's so important to remember why this is so important. Thank you.
Well, thank you. Once again, my name is Father Thomas Petrie. I'm a professor of theology at Providence College, and I'm here on behalf of Bishop Taubman, the Catholic Bishop of Providence. I want to thank Marion and the Taubman Center for inviting Bishop Taubman to come here on his behalf and accepting me as his representative. It's quite clear that marriage is a source of great joy for many people. And as a confessor, as a priest who hears many people's confessions, as a spiritual director, as a professor on a college campus, I know and am very aware that homosexual persons often face great struggles and prejudice. They are often bullied, they are often ridiculed, they often struggle to find their place in a world that seems to reject them and to find friends that accept them for who they are. Fortunately, I hope conversations like this and the progress we've made as a country with our increased tolerance of diversity, this is less and less the case. Now, I can say with confidence that neither I nor the leaders of the Catholic Church want anyone to be oppressed by the law, by the state, or by their neighbor. In fact, I would agree, obviously, that laws that decriminalize homosexual activity are indeed a good thing. What we do in our bedrooms is certainly a private affair. And so I welcome this panel discussion because it's a conversation that needs to happen. Because I believe as a priest that if there are members of our country who believe themselves to be oppressed, that needs to be discussed seriously, and they need to be heard. That being said, I also know there are homosexual persons, many of whom have gone on the record to suggest that access to same-sex marriage is not advisable or desirable. Some see it as too limiting. Some see it as too defined by the male-female relationship. The concern about equality, it seems to me, can only go so far. since as a society, it is a matter of fact that we do not grant equality to every opinion or lifestyle before the law. We simply don't. We do not grant equality or afford equality before the law to those in polyamorous or polygamous relationships. Why? We do not, in fact, grant equality before the law to those in adult, consensual, incestual relationships. Why not? We do not grant equality to those who insist in their speech in being hateful towards others based on their orientation or on their ethnicity or their religion. Why? It seems to me because before we even can begin to discuss constitutional principles or constitutional history, we must ask what the law is intended to do. And it seems to me that the law is intended to protect the common good. So what serves and protects individuals while preserving the society in which they live and in which they flourish? There are opinions, beliefs, and ways of life that we simply do not regularize or incentivize in law or public policy. And polling is not enough, really, to determine that. Because, as my colleague, Professor Cahill said, even Supreme Court rulings can be wrong. And even polling, even the majority of citizens of the United States can be wrong morally about what the right thing to do is. Had you polled the American citizenry in the early 19th century, I am convinced a majority of them would have said slavery was perfectly fine and moral. Had you polled a majority of a segment of the population in the 1930s, I'm convinced that a majority of them would have said segregation is moral. But we know, using reason and rationality and civil discussion, that these things are immoral regardless of what a majority thinks. It's quite clear that the government and law doesn't concern itself with every relationship. I'm a religious priest in the Catholic Church. I have a vow of obedience, I have a vow of poverty and chastity. To my brothers, I live with 40 priests on the campus of Providence College. The government does not recognize that relationship whatsoever. I am not married to those 39 other men, and let me tell you, I don't want to be. There are certain relationships that we all engage in. These relationships with those 39 other men, those other priests at Providence College, is very deep, meaningful, and emotional to me. None of us presumes that the government should recognize those relationships. Nevertheless, I have signed living will power, I've signed attorney of power, I've signed all sorts of documentations giving my religious superiors authority, not only of my goods, of my person, and making legal decisions on my behalf. It's quite clear that the government and law doesn't concern itself with every relationship precisely because the government doesn't care what kind of relationships you're in, frankly. Doesn't care who your friends are. The government doesn't care who you love. And neither do I, really. Friendships are not regulated or accorded any special status precisely because they are not concerned with the common good. And in order to discuss this question about the common good and marriage equality, we must first understand what marriage is and why it serves the society. That's why I welcome this talk, these discussions, because, as many of the advocates of same-sex marriage have noted, homosexuality did not break marriage, heterosexuals did. I agree with that. I concede that, all right? But yet, it's an opportunity to discuss what we mean by marriage. I'll say, and I look forward to having more questions about that because I have more to say about that, but I will say as a priest, it bothers me very much that this discussion cannot happen without those who take exception to same-sex marriage being referred to, akin, as my colleague here, Mr. Wu, just did, as racist and somehow equivalent to segregationalist? Is there a difference between ethnicity and sexuality and sexual orientation? Is there a difference between unjustly rejecting the marriage between a white woman and a black man and rejecting marriage between two men or two women? Can you engage in that question without emotion, with civil discourse, without sort of presuming that anyone who is against same-sex marriage is therefore somehow a bigot? And if not, then there's no way this conversation can go forward. That's all I have to say.
So I'll tell you, I actually in many ways agree with Jensen that this is not a religious debate, and yet I'm a rabbi. So here's the liberal religious perspective, and it's one that professionally I really have devoted myself to and believe deeply in. I want to tell you a story. My college, one of my best friends from college came out to me our senior year. He met his partner, now his husband, a year or two later. I knew both of them for 12 years and loved them both very dearly. And it was 12 years before these two people, very close to my heart, a wonderful relationship, were able to get married legally. They waited until the state of New York would recognize their marriage in Massachusetts. And I have to tell you, it's one of the most joyful weddings as a rabbi that I have ever performed, because their relationship had a decade of shared experiences, joys and challenges behind it, and all in attendance were really grateful to celebrate with both of them. And as I performed it, my heart ached, knowing that they had waited for over a decade to do what any heterosexual couple can do on a whim in all 50 states. My job as a rabbi, and I suspect I am joined by my liberal Christian and Unitarian colleagues in this sentiment, is to enable Jewish couples to sanctify their relationships. And until I'm able to do that in Rhode Island with the full, to the full extent of the law, that's really limiting for me. Under the chuppah, we say words that really, I'll tell you, are ancient words, and their meaning has changed over time. The feminists among us would cringe reading in the Talmud what Harayat Mekudeshet Li. It's setting one's. It's with this ring I betroth thee, and it's not the most feminist text in the world. It treats women as chattel, as property, and that has changed. Marriage has changed over the years. It is a fluid entity, even within traditional realms of Judaism, and I think we need to recognize that, so we realize that sanctification of a relationship is not dependent on gender. Marriage has always changed, and we need to evolve with it. I know in the religious conversation about marriage equality, there are always lines from scripture thrown around, and again, I'm hesitant to do that because I believe one can use text in positive ways and in negative ways, and again, the rabbis of the Talmud talk about using text as a sword, and I don't like to do that myself, but I will tell you that that there is a concept that comes from the book of Genesis called B'Tselem Elohim, realizing that every single person is created in the divine image. The Reform movement that I come from has always espoused marriage equality and supported those with different gender identities, realizing that each of us has that spark of the divine within. The conservative movement kind of added a different Talmudic concept to the conversation, kavod habriot, which translated means human dignity. I don't think I need to say anymore. I think those are both concepts that are absolutely central to this discussion. Every person has the right to a sacred, loving, to sanctify their loving relationship. I almost don't want to talk about Leviticus because it comes up all the time, and yet I feel like I feel like maybe I should just throw out there that it's that kind of elephant in the room. Leviticus 18, it's always out there, right? And it says homosexuality is an abomination. The Hebrew is toevahu. But anybody who's ever read the book of Leviticus will tell you that these same words are used in any number of other places. The book of Leviticus, read from an academic perspective, and even from the perspective that at Temple Bethel we read it during Torah study, is that it doesn't like confusing categories. That's what the priestly authors had problems with, and those categories can be combining certain foods, right, like milk and meat, certain animals that aren't like other animals, combining certain plants that aren't like other plants, or even linen and wool fabrics, and keeping that in the context of with an anthropological perspective, it really takes the meaning out of that verse. Leviticus 18, that, as I said, I don't really like to talk about, but it does come up in conversation. Many raise concerns about how the issue of same-sex marriage in Rhode Island would affect religious freedom. And I would tell you that each religious group is really free to define religious marriage in its own way. I regularly say no to weddings for all sorts of reasons. If somebody was to ask me to perform a wedding on Shabbat, on the Sabbath, I would say no. If someone asked me to co-officiate with the Reverend here, I would say no. If someone asked me to do it during my vacation, I would say no. It's my ability. I'm free to do that, and so that's not going to change. And I think, as we think about what this means to us here in Rhode Island, we need to keep in Roger Williams' vision for religious freedom that's so pivotal to the state's identity. I've been so moved in this last round of testifying that even my Orthodox colleagues have stood up. I'm on a board of rabbis that is completely in support of marriage equality, based on the idea of religious freedom and the separation of church and state. If you want to perform same-sex marriages, it's wonderful. And if you don't, then don't. But don't limit others' civil rights with bogus textual claims that force one religious viewpoint on all Rhode Island citizens.
Well, thank you very much to all the panelists, and we have allowed considerable time to have some discussion and question and answer. Let me just start, and I suspect that anyone on the end of Rhode Island, particularly focused folk, is why not put this sort of question up for voters in the state to determine? Is it the place of the legislature to make this decision, and yeah, so why not let if you will, democracy work its will and allow voters in this ocean state to determine this? Jansen, do you want to?
I'd love to. But first, I just want to apologize to Reverend Petrie. I certainly did not mean to communicate that I believe any person with strongly held religious beliefs is a bigot or a racist or a sexist.
No, I didn't mean to suggest that, but can I just, since we got...
Well, let me answer.
Okay, go ahead, yeah.
Thank you. And in fact, we are working with an Orthodox rabbi in our coalition who has expressly said he has deeply held religious beliefs that will prevent him. He will say no to any same-sex couple that wants to marry in his synagogue, and yet we're working with him because he believes that all same-sex couples should have that civil right to marry in civil marriage. And so I fully respect the deeply, sincerely, religiously held beliefs of many, many people. The point I was trying to make is that given that we have faced this question before time and time again, why are we treating this instance differently than we've treated the instances before in history? So that was the point I was trying to make.
Can I just say something to that quickly? even though I know we're still getting to the question, but can I just respond to that quickly? It is true that we've faced the question about marriage equality time and again. But one thing I would want to suggest is that it is different this time because there's something about what constitutes the definition of marriage. And is there something about the definition of marriage that requires masculine and feminine in a way that certainly ethnicity and skin color doesn't take into consideration? And this is what, going back to what Professor Cahill said, I have never heard that any known society has ever assumed or described any sort of relationship other than masculine and feminine as marriage. There may be other sorts of unions and other sorts of custom or social custom relationships of same-sex persons. But why do governments throughout human history, until the last 40 years, suggest that marriage is between man and woman? And why do we then say ethnicity is clearly an unjust reason to limit marriage? And I was just to answer the question, my sense is, politically, that whenever the question of marriage has come up on a referendum, 33 states have opposed it. The voters of 33 states have opposed same-sex marriage on a referendum in our country.
Jansen, do you want to address really the question of what's the appropriate mechanism for making this determination?
Well, I'll just, add that we elect our representatives to do their job, which is to represent us. And that is how our representational democracy works. And so if there are people who disagree with the representatives' decisions, there are consequences at Election Day. So that is how our government works. Just to give a little bit more of a less legal answer, though, about why these referendum campaigns are so divisive and harmful. I mean, LGBT community has faced more anti-gay referendum than any other minority in this country, by far, with regards to our rights to be teachers, with regards to our rights to have anti-discrimination laws, and with regards to our rights to marry the ones we love. And if you look at even the most recent examples regarding the marriage campaigns, and you look at the commercials, I mean, they're just extremely divisive and harmful, particularly to the children of same-sex parents. And just imagining, how difficult it is to have your kid in front of the TV and have to see all these claims made about their families, and really hurtful claims about their families as well, too. So that's, I think the most important reason. But of course, we have a representational democracy. We aren't supposed to be voting on minorities' rights through that system. And so I think that it really is a horrible idea to put this to a vote.
Can I just say one thing? When, on the eve of the Supreme Court's decision in Loving v. Virginia in 1967, I recently read that something like 80% of Americans opposed interracial marriage and interracial relationships more generally. So if we said today, okay, let's change those laws, let's repeal them, legislate or by popular referenda, we wouldn't even hesitate to say that you can't do something like that. So it's been sort of unclear to me why there's not a similar hesitation with respect to this particular context.
Can I say something, please?
You want to say something?
Yeah, I've been trying to
Oh, go ahead.
get a word in edgewise here.
Yeah.
I have to say I feel kind of torn on this because I think the anger that is the divisiveness that's happening in our country, a lot of it is feeling really angry that elites are forcing these things on people without even allowing them to vote. Now, I also believe that marriage is intrinsically by nature a heterosexual union, and I think that votes can be wrong. I also want to point out that one of the dangerous things, see, people who say, oh, it sounds like a good idea, they don't see the kind of things that are coming in the wake of such a decision. You look at the stuff that's been going on in Massachusetts, and this is the camel getting the nose in the tent. You've got people being prosecuted for, speaking their, preaching in their churches. You have people you have kindergarten kids being proselytized and accepting same-sex marriage. You have real infringements of people. I mean, I was sitting next to it at one of the hearings, a guy who'd been taken away in handcuffs for protesting his sons being indoctrinated into accepting same-sex marriage in kindergarten. It isn't, people want to get approved, but this is not the way to get approved. I mean, it's a violation of people's consciences, and I think respect for people's consciences is one of the deepest and most valuable things about our country.
Well, why don't we allow some audience participation, and if you will stand at mic, I will direct you and call on you, and let's be mindful, we want to try to get as many in as possible, so keep the statements as short and brief as possible, and let's make sure we have a question. I'm going to start with you, sir. How you doing?
Doing wonderful. First of all, thank you all for taking the time to speak with us from each of your perspectives. It is an important issue, and as someone who has a boyfriend, I certainly appreciate that you're all taking the intellectual rigor in order to discuss the issue. I'll speak as quickly as I can just so we can get through this. So the following organizations have all endorsed same-sex adoption as completely free of psychological, developmental, neurological, social development, or cognitive function, or self-esteem harm to the children of same-sex parents. The American Psychological Association, the American Academy of Pediatrics, the American Academy of Child and Adolescent Psychiatry, the American Academy of Family Physicians, the American Bar Association, the American Medical Association, the American Psychiatric Association, the American Psychoanalytic Association, Child Welfare League of America, National Adoption Center, National Association of Social Workers, North American Council on Adoptable Children, Voice for Adoption, and ACLU. And I'm wondering what specific psychological or developmental neurological arguments did they all get this wrong? And if so, on what metric have they got it wrong?
Yeah. May I speak on that? Because part of my testimony that got cut out was a discussion of Mark Regner's findings and his critique of the studies. See, it has been standard that the biologically intact family is better for children. Recently, the APA did a flip-flop, which was very clearly politically motivated. The studies on which it was based were, I'm not saying Regner's has proved everything finally forever, but he did find all sorts of, the children of same-sex, brought up by same-sex couples coming out lower and having more problems of a variety of sorts. And he pointed out the methodological problems. There was a rash of studies done with very poor methodology, which small samples, biased samples, recruited through gay, lesbian organizations, knowing that what they said was going to be politically important. Regner's attempted something really important. I don't say he did it perfectly, but he took a huge random sample and he tried to control for various factors, like did the children grow up in a gay-friendly community and so on. And he came up with the finding that in fact the children did worse on a variety of things. I could read you what the things were, but they're more depressed, likely to be unemployed, less healthy, cheated on spouse or partner, smoke more pot, had trouble with the law, report more male and female sexual partners, more sexual victimization, and were more likely to reflect negatively on their childhood family life. So I think if you get young adults looking back, you're going to get something more objective. And it's at least enough to sort of shake the confidence. I'm not saying it proves that this needs more work.
Thank you. And I'd encourage you maybe to look at the New Yorker critique of that study.
Actually, may I just respond very briefly to the Regner study? So the American Sociological Association filed an amicus brief in both marriage cases at the Supreme Court. Definitely a great look. The Regner study actually didn't compare apples with apples. It compared apples and oranges. So with regards to same-sex families, they didn't look at same-sex parents who had either children born or adopted into those families. They looked at families that were not intact to begin with, and most of these were heterosexual families where they break up and then one of the parents becomes is involved in a same-sex relationship. And then on the other side of things, with the heterosexual couples, you looked at intact families from the very beginning. And on the other side of it, the vast consensus of the studies over decades have shown is that there are really three main factors at the well-being and outcomes of children. The first is the relationship between the parent and child, the second is the relationship between the two parents, and the third is the financial means of the families. And so if you're looking at intact families versus unintact families, obviously one of those factors is the relationship between the parents. And so while many of the studies showing that children of same-sex parents have the same outcomes that everyone wants. They are not, there's no gold standards, they're not using the blind test and whatever else. That's very typical for that field, and what you gotta look at is the entire body of that literature over a decade, and the entire body of that literature over the decade is unquestionable.
Can I just say, just real quickly, I agree with exactly everything that Mr. Wu has said. The Regnier study is certainly faulty, there's no doubt about that, okay? But the fact is that there is no longitudinal study on the effect on children being raised by same-sex parents. We simply don't have it because it's all apples to oranges, right? But what the vast majority of sociological and child development studies do show is that family structure does matter to the outcomes of children. So whether we're talking about single-parent families, whether we're talking about being raised by step-parents, whether we're talking about nobody has gone then to talk about same-sex parenting. We just don't have the studies. But when we're talking about single-parent family, when we're talking about step-parent, the children always do worse in about 19 different indicators than they do when they're raised by biological parents. So if you're asking me, am I against single-parent family? Am I against step-parenting? No, obviously not. But I think anybody who's been raised by a single parent, and any single parent will tell you, that it's incredibly difficult, right? So the question is, and this is why I see it as different than the whole ethnicity issue, what is marriage, and do children benefit better from having a biological father and a biological mother biologically invested and emotionally invested in them? And it seems to me that the vast majority of the literature suggests yes.
Let's go over here, sir. You have a question?
My question is really directed to the Reverend, but also to Professor Wolf Devine. You said that you object to being labeled a bigot by supporters of same-sex marriage, and you said that you're not a hateful person. You don't sound like a hateful person. This is your sincere religious belief.
And
I guess
philosophical belief.
Well, that too. I guess my question is, to me, that seems kind of like a red herring, because if you oppose equal rights for a group of people, what does it matter what the basis of your belief is? For a long time, there was a Mormon doctrine that said that black people were morally inferior, and that was also rooted in a sincere religious belief. But no one would say that people who believe that are not bigots, because the question of belief is really irrelevant to the question of whether you're a bigot.
Okay, good. What's your name? Can I ask you?
Bradley.
Bradley, good. Thank you, Bradley. Bradley, are you in favor of polygamy?
I don't really see any reason why it should be legally restricted, but I think that's
okay. So you are in favor of polygamy.
That's not really what I said.
No, I mean, but that's what you said.
No, it isn't.
I mean, so you're not in favor of polygamy.
It's not a black or white question.
Well, that's my point. That's actually my point.
Wait.
No, I'm sorry.
Wait. We're going to have to keep this in some order. I think the question that Bradley had was directed
Why am I bigoted? Why am I not bigoted, right?
Please address that
sure.
question.
Absolutely.
And
well, it goes to my question about polygamy too, right? Look, what is marriage about? That's what the question nobody seems to want to ask. If it is, I'm going to go on record right here, and you can quote me in what's the Brown newspaper?
Brown Daily Herald.
Thank you. You can quote me in the paper, right? Here it is. If marriage is an emotional union, if it is about a solemn commitment of love, then I am in favor of gay marriage. If that's what it is. But philosophically and legally, I don't want to say love has nothing to do with marriage, but the idea that you are married to somebody you love is a relatively modern idea. It's a good idea. Right? But it's a relatively modern idea. Okay? Marriage, the reason states have protected marriage and incentivized marriage in the whole history of humanity is because the government doesn't care who you love. The government cares about producing and educating upstanding citizens for its state. And that's what marriage has always done until about the 1950s and 1960s. That's when heterosexuals broke marriage. All right, that's when marriage became, well, I'm just going to go and have this nice, beautiful, solemn ceremony, which is very emotional and wonderful, but it has no real effect on whether or not I'm going to have children. You see, in the 1940s, 1950s, a married couple would be having difficulties, they would always say, we're going to stay together because of our children. Our children need us to stay together. How many parents, how many people in this room, parents did not stay together? We're having, exactly.
But I think I grew up better for that fact.
Perhaps, but you don't know.
Okay.
But you don't know.
I want to say something to the, excuse me, can I say something to the bigot point, please, too? He directed it also. He
No,
directed
let's
it at
not,
me.
let's not go there. I want to,
Okay.
I want to go to the next question. And ma'am, you have the next question, please.
Hi, thank you. My name is Michelle Baye, and I'm here with a lot of other students. I'm an ally, a straight ally. And I'm just here to express my utter disappointment with the Daily Herald and with the Taubman Center for organizing this panel. Because what I think is completely missed by doing this is that in having this discussion, it was not a discussion about how gay marriage should be legalized, whether it should be by the states, whether the state has any say in who gets married to who at all. This conversation was, are gay people equal to straight people? And that is the fundamental issue that this has been debated. So we might as well have sat around and debated whether black people are 3 or 5/5 of a person, or whether women are rational enough to vote. And in 10 years from now, we will all realize that we sat in a room and listened to arguments about this, and I've never been more embarrassed of my school to have sat here and done this, and I'm so sad, and for all of you. So I hope that for the people that are on the side of not supporting same-sex marriage, that you realize that you are fighting a battle that you will lose and are losing, because every battle against love and equality and freedom in America is lost by the side you're standing on and will be lost forever.
Sir, do you have a question?
Try to give me a question.
My question's for Reverend Petrie as well.
What's your name?
Eli.
Eli.
I'm a sophomore here. Nice to meet you. I just have a question about the idea of whether marriage is predicated on love or on something about children.
Mm-hmm.
And if we posit that it should be predicated on continuing familial lineage and allowing children to be brought up, well, doesn't it logically follow that we should also then deny marriage to infertile heterosexual couples or those who are too old to have children?
Yeah,
and how do you reconcile that?
Yeah, that's a common question I get, of course. I think we all agree, I hope we all agree, that law certainly influences behavior, right? Whatever the law is, like if it's even little things, I don't understand, for example, why it's 45 on Interstate 95 between Providence and Pawtucket. I don't understand that. I speed in that section, okay?
It's the curves.
But I know I'm breaking the law. I know I'm somehow behaving badly, right? If you look at the introduction of no-fault divorce laws in the early 1970s, introduced first by Governor Ronald Reagan in 1972, is that right? 1972, no-fault divorce law in California. Marriages started to break down from then on, because from then on, state governments rescinded their responsibility and their interest in making marriages succeed, right? For the sake of children and raising children. Now, legislating same-sex marriage and making same-sex marriage somehow similar or equal to heterosexual marriage would simply, once again, remove what makes marriage distinctive, which is procreation. Because otherwise, any relationship should be recognized as marriage, whether it's polygamy, whether it's incestual, consensual adult relationship, right? If it's all about love, then I should be able to marry my mother. If I want to profess love publicly to my mother, I should be able to. Right? I wouldn't, but I should be able to. Right? So the question is, at that point, well, then why are we even having this discussion? Why is the government even interested in having an institution called marriage? Unless there's something distinctive about it that serves the state. Now, with regard to infertile couples, allowing them to get married, first of all, it would be a tremendous invasion of privacy to have couples prove that they're fertile before we give them marriage licenses. But it's not an invasion of privacy for two men to come up to me and say, yes, you cannot procreate. You do not meet the essential union of what marital love is. I have no doubt that you love each other. I have no doubt about that. And I want to protect that. I want you to get your jobs. I want all of those things. You know, let me be with you 90%. I will protect you. I will save you. I will serve you. I will love you. But I cannot, as a Catholic and as someone philosophically committed to the preservation of the state, I cannot agree with the behavior and the possibility that somehow marriage is this malleable blob that has no content.
Okay, good. Sir, you have the next question.
Yes, thank you. My name is Aiden Dunbar, and I would like to speak specifically to the issue of children of gay and lesbian families because I am one, and I would like to come out. Thank you. But that's my own little coming out thing. But I would like to say that a lot of things that have been said on this panel are horrendously offensive to me, the way that I was raised, and the family that I know loves me. My family and my, don't pause me, I get emotional about this. My parents love me very much, and that is what enabled me to have a successful childhood, and that is what enabled me to be the person that I am today, and to be where I am today. And for you to suggest that for some reason that I long for like a male role model, I know my father, I know who he is, and the idea that my father is the only person that can be a male role model is also incredibly narrow-minded. I found male role models across the board. Because of my father, I have 2 dads and 2 moms. Yes, I know, it's confusing, it gets weird,
Yeah.
but
Trying to figure it out.
yeah, I know, and I'd be happy to explain it to you because you obviously have a lot of misconceptions about what it means to be raised in a gay family. And I would like to offer myself as an example of the fact that it does work. You say it's unproven, it's untested. Well, me and all of my friends of these same families would very much beg to differ, and that's all I have to say.
I have a good friend who's also a son of a gay lesbian.
Marion, comment?
Just
Yeah,
so you know.
one,
Yeah,
one second. My father, Professor Self, wants to make a observation.
Sure. First, I just want to recognize the young woman who spoke before, and I think philosophically and ideologically, I'm very much in sympathy with that position. I think we can't proceed with the panel with the assumption, respectfully, that marriage has always been one thing. I just jotted down a few things. It united families, and it was used, as people know, politically. Marriage played an enormously important role in structuring familial power in a variety of societies. It has played an extremely important role in distributing property, for example. In fact, it's one of the most important institutions in human social organization for distributing property. It has served an incredibly important role in regulating labor, including the labor of women and children. It has determined legal sexual access of men to women. It's played a hugely and enormously wide range of roles in human societies over time. There isn't a single role that marriage has somehow transhistorically played. Many of those roles we have abandoned because we have found them to be oppressive, limiting, constraining, unequal, and so forth. And our society is evolving, and I think what's happened in the last 25, 30, 40 years is that people have decided that this is yet another aspect of the marriage relationship that needs to be discarded. But I don't want to proceed as if there is one historical frame in which to see marriage, and everything that deviates from that is somehow a problem. Marriage has occupied a variety of different kinds of roles, not simply to protect children and not simply to ensure proper citizens.
I did not mean to suggest that all children of who had been raised by same-sex couples, which it seems you haven't, because you have 2 fathers. There are 2
I
men
lived with my 2
involved in
mothers
your
and I
life
was raised
here.
with them. So
What?
yes, I lived with my 2 mothers and I was raised with them.
But
so
you know who your father is, and you have
yes, and
some sort of,
so do many children
yeah.
of gay and lesbian
So
families.
this is a somewhat different case, but I'm not suggesting
not.
that you're going to be. You don't know what's going to happen down the line. I mean, kids wonder, will I miss my father? But you've had men in your life. You can mitigate the damage, but it's not ideal.
What damage? In what way am I damaged?
Hard. What?
In what way am I damaged?
Listen, let me just sort of interrupt us because we want to try to
I don't
get
know
some
you.
more questions.
She hasn't answered the question. She hasn't.
I don't know you. I couldn't possibly say.
Okay.
On the whole, and
Over-
for the most part, it's better for children. That's all I can say. On the whole, and for the most part.
May I just ask you, what way am I not damaged?
Wait 1 second, ma'am, please. Let's try to keep this as much as order as possible. Let's go over here, sir, please.
Yeah, my name is Kevin. I'm a graduate student here at Brown, and I have a question for Rabbi. You used the phrase in the light of God or in the image of God when you were when you had your speech. Where does human free? I mean, we're all rational creatures. Where does free will come into play in that, and sort of in your view of of marriage and your definition of marriage.
In terms of free will, in terms of choosing a partner? Or?
Yeah, the choices we make about our families and who we want to be with. And
my understanding is that we are born the way we're born, and it really is not a choice. And we, if we're lucky, are able to choose the person we love, be that of the same gender or be that of a different gender. And that, I mean, I'm not sure if that answers your question, and that in my mind is how free will enters it, but that no matter what choices we make, we are all do all have a spark of divinity within us, and does that? I'm not sure if I'm answering your question, because I'm not sure if I understand it. Does that help?
Yeah, it just seems as though in the traditional sense of marriage, and we've heard of examples today that are clearly not rooted in a religion, and they may be cultural. It just seems that, to me at least, when you with phrasing like that it just sort of takes the choice out of saying that things are one way or another, and I don't know. It's something. The choice, the choices we want to make about who we want to be. It just seems very limiting, the way you phrase that.
I think maybe we're looking at. I'm not sure if we're looking at it from different perspectives. In my mind, it's not limiting at all. I mean, in my mind, I'm thinking maybe that there are some things about which we do not have choices, and that in many ways it can be very affirming to know that no matter who we are, we do have that spark of divinity, and we all make bad choices. We all make good choices. Free will to me is like a totally different sermon, if you will. You know what I mean? In some ways, it doesn't figure into this conversation, because I guess I don't see this as a choice. I mean, I see this as a way a person is born, and that we are here to affirm the reality that every person is created this way. So I don't know if that answers your question, but I think it's maybe because in my mind, free choice is just something else entirely.
Let's go over here, sir. You have a question, and listen, guys, we're going to run out of time. So you guys need to be succinct and put your questions out there. And I'm going to ask my panelists to try to be succinct also, that we want to try to give these folk who are standing up there a chance. And we're going to run out of time because my wife just called and said that she had dinner ready, and I'm sorry we got to get over here. I know this is important.
I will seek for succinctity. So. I'm Len Katzman. I staff here at Brown, but for 10 years I have been working for marriage equality, political behind the scenes, talking to legislators and doing things that folks in politics do. And so I've testified before the committee.
Question.
I'm getting to the question. And I hate to pick on you, Reverend Petrie, but you represent the Diocese of Providence, and that is with whom I have the greatest political beef, and that is, you said the church doesn't want anyone to be oppressed by the law. Mm-hmm. I'm a Jewish man. The Central Conference of American Rabbis and the Rabbinical Assembly, representing the vast majority of Jews, 81% of Jews support marriage equality, and including our governing authority bodies, have affirmed and embraced marriage equality. I am clergy at the Newport Havarah. I am, by Rhode Island law, legally able to marry, solemnize the marriages of people. Yet if a Jewish gay couple comes to our congregation, I have to tell them the laws of the state of Rhode Island oppress the free exercise of the Jewish people. And if marriage equality passes, I promise you, Reverend, I will never let the law force you to marry anybody you don't want to marry. But today, you are asking that the law prevent us, my congregation, from marrying who we will.
Once again, I think that the position of the Catholic Church on this is that this is not simply a religious issue, it's a social issue.
Which is why I will never force you to marry anybody you don't want to.
I appreciate your word on that. I appreciate your word on that.
Not
but you are aware that the federal government is now trying to force the Catholic Church to buy contraception and abortifacient drugs.
We're talking about marriage equality.
I understand.
Today.
I'm just saying you can understand the reticence, perhaps, right?
Perhaps.
Okay. It's about, the question is, once again, what do we mean by marriage? And that's why I welcome this discussion. That's why I welcome this panel. If marriage is simply about solemnization of love, then I'm in favor of gay marriage, and I think every society should be. But I think marriage is about how we raise and how we produce citizens for our country.
Thank you for the answer. I'll just close with this one sentence, and that is, you said that sometimes even the majority can be wrong. Reverend, the earth actually revolves around the sun.
Okay, now
So,
here's
and the
what
Catholic
we're
Church
gonna do. We're
believes
gonna
that.
take-
Can I,
Yes, we did.
one possible,
Augustine did, yes.
Can I
yes.
just put
Galileo, don't pull up Galileo.
one possible thing I might
Galileo
think
couldn't
about.
prove his
No,
theory, and his
no,
fellow
listen.
scientists knew that.
People, please, let's, no, I want to go to the question.
Let's get the question.
My question
Please.
is,
I'm getting
Let's get
oppressed.
let's get your question.
Tape on my neck.
excuse me.
Okay,
my
what question, your question, and then I want to hear the next person behind your question, okay? So ask your question, and we're going to see if we can get several asked at one time.
My question is to Professor Cahill or anyone with a legal background, and is when did the government begin to put a moral judgment on who can get married? Actually, as it stands today, we don't prevent anyone from getting a marriage license who's heterosexual, and I could actually go to a woman right now and get married, go to the courthouse and ask for a license. So if we don't, and I don't think I should do that, I don't think people agree here that I should marry anyone that I meet today. So if we don't prevent those people from getting married, why are we preventing LGBT people who have loved each other for years and decades to be married?
Okay, thank you. Sir, your question, please.
So my question pertains mainly to the invasion of privacy argument. So my question is, are we supposed to do a masculinity or femininity test on people who get married?
No.
Because we have intersex individuals, we have people that could identify as either male or female, and is it up to the state to decide that they can or can't be married simply because of their sex?
Hi. Hello. I understand, as you were saying, Reverend, that marriage isn't only about love. And I want to ask you to further discuss the problems that arise when you focus on the definition of a word that has significant political and legal ramifications, and how a limiting definition of that word affects those ramifications, who can participate in those, in the things that are enabled by people who are able to buy into that word. So I'm asking about the intersection of semantics and legality.
Okay.
Thank you.
Professor Cahill, your first question was about legality and the extent to which the government should be involved in this particular issue.
Well, I think the student or speaker asked whether or not, it is true that the government sets what is called both formal and substantive requirements for marriage. One of the substantive requirements for marriage is the gender requirement in most United States jurisdictions right now. But you're completely right that the government does not regulate marriage on a deep substantive level. The whole point is that you can marry the person sitting next to you. I don't have my glasses on. I can't say if it's man or woman. So it's like you can marry anybody, right? So long as you satisfy the very surface substantive requirements for marriage in that relevant jurisdiction, including the number requirement, the gender requirement, and the
Age.
the age requirement. It's very easy to get married, right? It's extremely easy to get married. The government stays out of our business with respect to why we get married. It just regulates who can get married.
Can I just add? It's extremely easy to do, but as the gentleman here said, it's connected to a whole set of interesting enabling. Right. It's deeply embedded in virtually every institution, so it's actually very easy to get into, but it's connected to this web of rights.
Well, one thing
I really want to make certain that we get enough voices here, so I want to hear your question, sir, and then right behind him you have a question, and then we can move on. Sir.
Okay, my name is Jim Hutchison. I'm also a staff member here. My question is for the Reverend Petrie. I've been in a relationship for 21 years. My partner and I admittedly are unable to bear children because we're both males. We're both members of the Roman Catholic Church. We're not looking for a marriage within the Catholic Church. We're looking for a civil marriage in order to gain the over 1,000 federal benefits that are available to the heterosexual couples. So my question is, if marriage is about bearing children and furthering society, you've already discussed that it's an invasion of privacy to ask if you're infertile. But what would you consider a person of advanced age, female, that is obviously past the childbearing age? Let's say they're 65 or 70 years old. Are they eligible for a civil marriage license from their local town clerk?
Very good, thank you.
Okay,
Thank you.
don't answer that. Let's go to the next question.
All right.
Hi, my name is Sean Saunders, and I am a gay male of a single parent household. And I was wondering kind of how single parent, I'm not sure if this question was already asked, but how single parents factor into this discussion of children, because many studies say that like two-parent households are apparently the best, but as a child from a single parent household who has never longed for a dad or a male role model, because I have plenty of them, what does that factor into your considerations? Because it becomes a dangerous rhetoric that now, like, who else cannot be allowed to have children if we don't believe that gay people can? Do we now stop any like unwed mothers? Do we stop like anybody who's like, you know, surrogacy one person? Like, what's the limit to that argument?
Okay, good. So we have a question about childbearing still, and then this question about the role of single parents, and then we're just going to have to end it there. Unfortunately, we could talk about this for the rest of the evening. I'm
Yes.
sure.
Can I just say a couple
These two
things?
here.
Can I just say a couple things on this? First of all, even though the literature is very clear that children do best when they're raised by a biological mother and a biological father, that doesn't mean every child raised by a biological mother is going to do as better than, say, there are a couple of people who got up and said, yeah, no, they're single parent, or I was raised by two lesbian mothers. I will note there has never been any study about children being raised by two gay men. There's no study at all anywhere in the literature on this. All right, that being said, I do think, going back to an earlier, before we moved on, that there is certainly confusion in our culture about the benefits of women and men. That women and men see the world differently, and they raise children differently, and they interact with their children differently. There's no, lots of developmental literature suggests that. Finally, about invasion of privacy and this question about this gentleman over here, which I didn't get to answer, about the meaning of the word. We allow couples of advanced age to marry. We're still upholding the good, that marriage by definition is between man and woman, regardless if they actually bear children or not. Just like a baseball team has a certain configuration, regardless if that baseball team wins or not, right? Regardless if it's a loss. And infertility for many married couples is a loss. They experience it as a loss. Now the question about the word marriage, and you can quote me on this, I do not think that same-sex couples are being discriminated against because they have a right to marry anybody else of the opposite sex that anybody else in the room does. This is why it's different than the anti-miscegenation laws. What the movement wants, what this discussion is about, is not about the right to marry, because you have the right to marry, according to what the law says marriage is. The debate is about what do we mean about marriage, and should that definition change and be modified?
Good.
And I think we can have a real discussion about that without sort of the emotion of calling me a bigot, because I think the definition is fine.
Okay. Let's hear your question, sir, and then let's hear yours, and then we will get the responses, and then we will wrap it up. Your question, please.
For the Reverend Petrie and Ms. Wolf Divine, you're obviously not in favor of same-sex marriage. That's pretty clear. But do you believe that same-sex couples should be allocated the same legal and civil rights as heterosexual couples? Why or why not? Even if you can't call it, even if you don't believe in calling it marriage.
I'm glad you asked that, because I meant to say that.
Let's hold up. That's one question, and let's hear your question, sir. We can get your response to those two, and then we will conclude. Go ahead, sir, please.
Yeah, so I mean, I recognize your point that like there are outliers, and you know maybe the like normal structure is going to be true in all cases. I'm also one of those outliers. I had a very abusive alcoholic father that I moved away from 5 years ago. It was the best thing that happened to me. And so I think that, often this is like heterosexual families also like a place of like intimate violence. It's often like overlooked. And my question is that given that adoption, surrogacy, and artificial insemination are inherently deliberate choices that require a great deal of preparation and vetting, wouldn't LGBTQ parents be on average, better prepared to have children than most straight couples?
Okay, let me just say, can I answer that? Answer your question. I think that's an open question we can all sort of discuss. I mean, I want same-sex couples to have similar rights and benefits, and whatever we need to do in the law to do that, And like I said, I'm a religious priest, and my superiors, if I were to get an inheritance of $1 million, there is no way my siblings can get that. We have that rock solid, okay? I think I want that. What we call it, but the question is it marriage? Could we have the same sort of legal setup for two bachelor brothers who are taking care of each other? Okay, but is it marriage? No, right? This question about outliers, I agree with that. I mean, not every father is a great father, but this is precisely part of the issue of same-sex marriage. That even President Obama recently said children need their fathers. They need their fathers. And marriage puts the human male in a relationship with the mother of his children. Human males are the only upper primate species that recognize their children physically. And marriage is a legal bond so that human fathers are connected to their children.
Can I just respond to, I'm sorry, I've been being driven crazy by this conversation, not as a rabbi, but actually as a mother. So I speak from that perspective of two little boys, and studies, schmeddies. Children do not care who raised them as long as they are loved. And it's
Listen, we're going to bring this to an end. Let me say, first of all, thank you to the panelists. Please thank the panelists. Thank you for your participation, and thank you all for being here. And finally, let me thank the students from the student newspaper for their involvement in this very, very important discussion. Thank you very much. Have a nice evening.